No matter your age, your plan for retirement can start today. From the News Channel 5 Network, this is the Retirement Report.
Good morning. Welcome to the Retirement Report. I'm Hank Parrott, your host. All right, we're going to be talking estate planning today. This is one of those areas that I've dealt with, and by the way, in my book, 7 Steps to Financial Freedom in Retirement, one of the things we talk about as well is in the chapter 7 is estate planning. This is one of those areas that when done right, you're going to get a lot of benefits from it, but if not done right, it can create some real problems, not only, after you're gone, but during your lifetime as well. So one of the things we're going to get into, for instance, are the 5 essential documents. So I'm going to talk about the basics of estate planning. We're going to get into the difference between wills and trusts and what they, how they work with regard to estate planning, what the impact would be for you in your estate plan, depending on which of those you might elect. We're going to talk about powers of attorney, the importance there, durable power of attorney for assets, durable power of attorney for health care. We're going to get into why those are important and some of the pitfalls that a lot of people may, you may not be aware of things that we take for granted in terms of what we can do. An example that I've talked about is that of not having a power of attorney. If one becomes incapacitated for a couple, the other spouse might not be able to access, well, in fact, would not be able to access the retirement accounts. And let's say you need to get money. It could be, that could be a pretty terrible time as far as health issues and that. You might need to access retirement funds to help through that period, and you wouldn't be able to access those without a power of attorney. Or you'd have to go to court and talking about conservatorship and what that looks like. So there's a lot to cover. And with me today, my good friend and special guest, Russ Cook with Russ Cook & Associates over in Brentwood, Tennessee. Russ is a board-certified estate planning attorney. He's been doing it for almost 30 years.
30 years, yeah.
Wow. So,
yeah. Thank you, Hank.
And, Russ, this is one of those areas that we talk about, like the 5 essential documents and the value of them. So again, those 5 essential documents are going to be a revocable living trust, pour-over will, the powers of attorney that we talked about, and a living will. And let's start with why would someone want a revocable living trust, say, as opposed to just getting a will?
Well, thanks for having me on, Hank. I really appreciate it. The normal way, or I guess to start out, the typical way that you'll see people plan their estates is by using a will. A will is basically a document that doesn't take effect until you pass away.
Can we do the monitor too on this one?
And the document that we're using as the will, we have to file with the court in order for it to be effective. And so when you're having to submit the will to court, that's the process called probate. Now, probate doesn't necessarily have to be a big deal in a lot of situations. However, a lot of folks like the idea of avoiding the probate process because they feel like there's a lot of information that gets disclosed as part of that process. You're hiring an attorney, you're having to file petitions, so it's more expensive. The revocable trust, on the other hand, is an estate planning document that is effective when you sign it. It's basically creating a bucket now that you can put your stuff in, and then when you pass, you just pass the bucket on to the successor trustee, and he takes care of things for you according to the instructions in the document. So in a lot of cases, that does avoid that probate process, which people see as a problem when they're trying to transfer assets to their loved ones.
Yeah. This is one of the things. Probate is, in Tennessee, Russ, of course, a lot of attorneys will say probate's not that big a thing. It may be in terms of the expense or the time, but it's still, compared to a trust, they're going to have to, it's going to take probably, on average, I expect about a year. You've got filings that you've got to make. There are things that you're going to have to do as a part of probate, or at least the family now is going to deal with when you're gone. In long term, I would say that if you look at doing a trust, you're still going to be less money up front, even though it costs a bit more than a will to set up, of course, than you would going through probate. Would that be accurate?
Yeah, it is. And there are a lot of benefits to doing your estate plan through a revocable trust other than just avoiding probate. If you're a married couple and you have capital gain assets, your home, vacation home, investments, then you can do a revocable trust called a community property trust, which allows you to get a full step up in cost basis on the assets that are inside it when the first spouse dies. You do not get that with a will. With a will, you only get a step up in the decedent's half share of the estate assets. With a community property trust, you get a step up in cost basis on both the decedent's half share and the survivor's half share. Another thing that we found just recently that actually I haven't really discussed at length with you, Hank, is when we're designating beneficiaries of IRAs, especially when we're passing assets down to the kids, and we're wanting them to go in trust, if you do your estate plan through a revocable trust, then it's easier to maintain that beneficiary designation. If you do your estate plan through a will, and let's say you name a trust under a will and then you change the will, then you got to change all the beneficiary designations at the same time. Because whenever we change the language of a trust, we're just amending the existing document. It's so living that we can keep going with the original one, and all the designation of assets, retitling, it just kind of flows through. So there's a lot of benefits to it beyond just the probate piece of it.
This is one of the areas when we get into, when I do reviews with clients, of course, one of the things we talk about, Russ, is making sure the beneficiary designations stay up to date. Now, Russ just hit a lot of different things. If you break these down, and that's what we're going to do, we're going to break it down a little more detail for you. So an example would be that of capital gains. All right, when he's talking about a step up in basis, understanding if you've got highly appreciated real estate, if you've got highly appreciated stocks or mutual funds, a portfolio such as that, if you want to cash those out, or if you need to access cash, you're going to have capital gains tax, and that depending on your tax bracket. And of course, tax laws are getting ready to change. All right, we'll see how this part of it comes into play. My expectation would be we've got 10 and 15. If you're in a 10 or 15% tax bracket, you have zero capital gains tax. But if you're above that, you're going to have a 15% capital gains tax. Now, the gain itself is going to count in terms of potentially pushing you up into a bracket where you're going to pay a tax. At the highest bracket, you'll pay a 20% capital gains tax. Now, with what we anticipate with the new tax law, if they are going to collapse down the brackets, so we'll have a 12% bracket instead of a 10 and 15% bracket. Well, then the expectation would be a zero tax for that one, and then a 15% tax if you go above that, and again a higher tax on the higher one. So think of that. If someone passes, all right, the first of the couple passes, that survivor's probably going to need some money, okay, to continue. They're going to lose probably some income. One of the Social Security checks is going to go away as an example. There could be other income loss in terms of pensions. Maybe the pension goes away completely, or maybe it's reduced down to half if you have a pension. So one of the things there, being able to access additional cash, this is where that capital gain, maybe being able to sell off something, could be a value and a benefit to you. Maybe the being able to manage these things is another area, if we're talking about real estate, to where that might be a time when you're saying, well, I don't want to do this anymore and I need to kind of make it easier. Well, this is where that step up in basis is going to be a big deal. You're not going to have to worry about the tax ramifications of that and avoid those taxes. So, one of the things when it comes to planning, and we get into whether it's capital gains taxes, income taxes, ways to reduce taxes in general, we want to make sure that when it comes to the only one losing in this thing, it's the IRS, all right? They're the only ones we don't want to have as a beneficiary as far as the planning goes. And what Russ was just saying as well about the beneficiary thing, this is one of those areas that there's been horror stories about where beneficiary designations were not kept up to date, where especially like IRAs or life insurance for that matter, anything such as that, and it ends up going in a different direction. The money goes somewhere you did not intend it to.
Yeah, that is a very important piece of estate planning. Always review your estate planning beneficiary designations, especially when it comes to retirement accounts, because they're governed by the federal laws, some of them, and the state laws with the IRAs. But I found that when we do a review for a client or initial intake meeting, they're not quite sure exactly who they've named as beneficiaries. And we also do a lot of estate administration, and we find that if the beneficiary designations are not done properly, then it's going to mean more income tax at death, because you're having to push all the income into 1 year because you're having to claim it. or you're not getting the children or whoever the beneficiary is the maximum opportunities they have to protect those assets and make sure that they're available throughout their lifetime.
In fact, we're going to take a break. When we come back, that's one of the areas I want to delve into, is about the asset protection features when it comes to estate planning as well. Imagine that. If you could, if understanding the way that these things work, Russ just alluded to that about IRAs. This is an area we're going to talk about, because with your IRAs, if you have certain protections under either state law with the IRAs, and with your company plans, it would be federal law. You have certain protections there. However, that same protection is not afforded to your beneficiaries when they inherit, at least non-spousal beneficiaries. And we're going to talk about that and how you can, though, add a layer of protection to make sure that those funds can still be there for their benefit as you would intend them to be. But first, we're going to take a break. So join us here. We'll be right back on the Retirement Report.
This is a Storm 5 HD weather update. Sign up for Weather Call.